Next, we have someone here from Immigration Voice. You'll have to help me with that. And your name, sir?
My name is Vivek Babu.
Well,
And
please,
okay, yeah, I'm the Vice President and Michigan State Chapter Head of Immigration Voice, which is basically a group which deals with the highly skilled employment-based immigrants. And we support the efforts to give us, the people who are here legally a driving license. But we have some concerns with the current bill. And our main concerns are, first thing is, like an immigration attorney pointed out, there are some, cases where a person can be here legally, but he has no proof to, prove it. For example, if a person is on H1 or L1 or any other visa, he can apply for extension of status. And the Immigration and Nationalization Act does provide a 240 days of grace period. So this is because of the USCIS processing delays. And till the point this is not approved, a person can be here for 240 days without, any proof in his hand that he is legally here. And this is allowed by the Immigration and Nationality Act. And we are concerned that the new bill is trying to define the, immigration categories. I believe the committee should leave it to the U.S. government, to define these laws. Because the U.S. government laws keep changing because they come up with new visa categories, and it would be very difficult to keep the bill in sync with the federal level. And so that is one of main concern. And other concern is the bill, again, it should refer to the Real ID Act instead of including the language from there and making it more restrictive. For example, the Real ID Act, section 202C2, which defines this particular, like who is to receive a temporary license, does not put even a license for just 1 year. And that puts us into a lot of trouble because we have to renew our licenses every year for the next 6 to 12 years, because that is the period of time we need to be in the line because of the immigration backlogs. So I think the bill should leave it to the Department of Homeland Security, because they give us a work authorization and work permit to work here, and there are changes happening there. DHS is considering giving us like a work authorization for up to 3 years. And if the language hardcodes it to 1 year, like we would not be able to take the benefit of that. So I think it should be the language of the bill should be changed in such a way that it says that a person should be given a license for whatever period he is authorized to work by the U.S. government.
I appreciate that. Is that the conclusion of your testimony?
Yeah.
Thank you very much.
Thank you.
Thank you. We got Vermulapalli. Huh? Yeah.
Thank you, Mr. Chair.
Thank you.
I'm Srinivas. I'm an information technology specialist working in the auto industry in the Detroit metro area. I'm here representing the immigration. Present before this committee some of the issues that would be faced by those like me with proposed changes to Michigan transportation law by section 310F of Senate Bill 962 of 2007. The U.S. immigration law is rather complex. Immigrants like me and employers of foreign nationals frequently retain attorneys who specialize in immigration law to assist us in navigating this complex system. The proposed new legislation will require Secretary of State employees to be trained some of these aspects of immigration law. They need to be trained in understanding the multitude of U.S. visas and immigrant statuses. Otherwise, they may end up rejecting driver's license in error. Hence, the bill necessitates the Secretary of State to allocate resources in providing the necessary training in federal immigration law although immigration is not really the purview of the department. 310F of 5 requires that the Secretary of State verifies with USCIS the status of the applicant for each renewal. This rule does not take into consideration the likely USCIS delay to provide this verification. Combined with 2, which limits license to 1 year, a green card applicant could be without a driver's license for some period of time every year. Waiting times for legal immigrants to attain the green cards are approaching 10 years. The law, as written, could potentially necessitate up to 10 such trips to the Secretary of State office and quite possibly multiple delays over this waiting period. Those awaiting adjustment of status are deemed to be in a legal immigration status until their case is adjudicated. My case has so far been in the status for nearly 3.5 years. Absent government issued IDs valid for anything exceeding a year, things like obtaining mortgages or business loans will become increasingly difficult as banks often will not accept foreign documents. This will basically prevent legal immigrants like me from reinvesting our earned incomes back into the local economy. It is our position that the integrity of the state driver's license can be achieved without making the process strenuous for those with pending adjustment of status applications, international students or other legal temporary residents. A more simplified procedure will not only make it easier for legal non-permanent residents, but would also prevent Secretary of State from getting overburdened by a complex law that would be very cumbersome to administer. We have some recommendations as follows. The Secretary of State can continue to issue 4-year license to adjustment of status applicants and annually verify the continued pending adjustment of status with USCIS. If the verification fails, then the Secretary of State can suspend or revoke the license after issuing a notice to the applicant. The second suggestion that we have out of the 4 suggestions is, bearing in mind the potential delay of 2 to 3 months by USCIS in issuing verifications requested by the Secretary of State, renewal driver's licenses can be issued pending verification. If the verification fails, then the Secretary of State can suspend or revoke license after issuing notice to the applicant. A receipt notice from USCIS should be an acceptable proof that the application for adjustment of status is pending. I know of no other way such applicants can prove this to the Secretary of State. Additional external checks on renewal should only be required if the information provided by the applicant, such as name, social security number, or visa status, has changed. I request that the committee keep up in mind the difficulties faced by law-abiding legal immigrants while changing the current law to allow issuance of driver's licenses to legal non-permanent residents. Thank you, Senator Gilbert and other committee members.
Thank you. We're just about to the time where we're going to have to vote on these. My apologies to those who did not get up. We did our best. And quite frankly, we did far better than I thought I would when I originally saw the pile of cards that we had. The first thing we need to do is adopt a substitute for Senate Bill 962.
So moved.
Moved and support. Will clerk please call the roll?
Senator Gilbert?